Please. Who do we have here, Greg?
See Mr. Zenon, Your Honor.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle.
Yikes. 10 years on the table, and this man still thought it was a good time to roll the dice again. How many second chances does one guy get before the court runs out of patience? Let me know in the comments. Is this a justice system giving grace or just enabling bad behavior?
Which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last
10 cases in just over 2 years. This dude's rap sheet reads like a fast food receipt. Weapons charges, assaults, and probation violations. At some point, you gotta wonder, is he unlucky or just unapologetically committed to bad decisions?
2.5 years. 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading, and now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate it, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana.
Here's where the stakes really jump. Threats of violence, resisting arrest, and multiple eyewitness accounts. If you're the judge, do you chalk this up to a heated moment or see it as part of a larger, dangerous pattern? Hit pause and think, what would you do?
The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going
How-
blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, it's a,
That phrase, like terroristic threat, sounds extreme, but legally, it's any threat that causes fear of serious harm. It doesn't take a bomb or a manifesto to cross the line, just words that hit the right nerve. So yeah, the bar may be lower than you think.
is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're
I understand
and they're a 0.1 mile away from the location.
So-
for what?
Well, okay, I get that, but so we've got a disturbance at HEB. Cops go there,
Okay.
they start to talk to him, and I guess at that point says, hey man, I'm gonna slap her. So at that point, I mean, that's what we have,
Okay.
right? Mr. Zenon, there's always 2 sides to the story. I get it. This is
where legal nerds start salivating. The judge dives into the actual statute, and let me tell you, it's murky. Interrupts, disrupts, impedes, or otherwise interferes. That's lawyer speak for we'll figure it out as we go. Would you be able to tell what counts as interference just by reading that?
probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault with Judge. I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
I think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know? If,
but they didn't
Hit.
They took the one that I do not believe applies here.
let's read the code. Let's see what the code says, because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
that.
the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all described.
They put
the
him, I
defendant.
guess, did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean,
0.1.
did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the Miss Clark.
And it's at that point they start to put him under
At
arrest?
that point, they ran him through the NCIC and they found that there was an active warrant.
Quick reminder, probable cause isn't guilt, it's just maybe. The bar is low here. Think of it as a TSA check. You don't need proof someone has a bomb, just a reason to peek in their bag. But even that little peek can land you months behind bars waiting for trial.
And then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or pushing.
Remember,
That's
I
a
mean,
resist.
it-
That's not interference
it
with
could
public
be-
duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's.
Okay, well, I mean, but so
I mean, we don't know. I mean,
Okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report
We
yet,
don't
Judge.
I don't
That's
care. I
he
mean,
was in
but
the
I think that
process.
there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.